Hello and welcome to TalksOnLaw. I'm Joel Cohen. Today we're going to be talking about mental illness and Second Amendment rights. And we have a wonderful guest. Jody Madeira is a professor of law at Indiana Bloomington's Maurer School of Law. Jody, welcome back.
Thank you so much.
Today we're talking about mental illness and the Second Amendment. I guess it's intuitive that if there are extremely dangerous weapons, perhaps those with a certain level of mental illness shouldn't have them. Maybe you could give us a quick overview. Is there a basic threshold for mental illness that impacts on the Second Amendment?
Yes. And just as a caveat, nearly 50% of Americans will actually experience a mental health condition at one point in their lives. And we actually talk about mental health on a daily basis. We can say we're feeling depressed, we're feeling elated. These transitory or more transitory states are not what we're talking about when we talk about a mental health condition. The mental health conditions that are actually at stake here are not only diagnosable, but they've had particular consequences. And so, for example, federal law prohibits some individuals with mental health conditions from gaining access to firearms or ammunition. Basically, and the language is very, very cringy here. The language requires that the person has been adjudicated as a mental defective. Again, very, very outdated.
Yeah.
Not what we refer to at all as a person with mental health needs, or they have to have been involuntarily committed to any mental institution. And so if someone is involuntarily committed or adjudicated incompetent by a court, then they're reported to the National Instant Criminal Background Check, or NICS, and they're barred from purchasing a firearm.
Interesting. And I do see that language is coming from a former era and also perhaps counterproductive. I mean, you're not only going to take my guns, but you're going to call me a mental defective?
Yes, exactly. And so it's very backwards. And again, it also presumes, and the federal law presumes as well, that if you have a mental health condition, there's sort of no revoking it. And once with a mental health condition, always with a mental health condition. But the very fact that 50% of Americans have a mental health incident at one time or another just shows that it can be transitory, it can be temporary. And again, very few individuals who are subject to these federal requirements are individuals who we think should be barred for life, perhaps.
And you mentioned a couple of areas where weapons can be taken away involving mental illness. One involved commitment. Does that commitment need to be for a violent issue?
Basically, it is usually taken for granted under these federal provisions that if you're involuntarily committed, you're going to be at risk of doing yourself harm or doing others harm. And it need not be violent. Perhaps, for example, you have a mental health condition that makes you run away. And there's a concern that you could run away and become endangered because of exposure to the elements. It does not mention, for example, a requirement that you yourself be at risk of doing yourself harm or doing another individual harm through violence.
And this is actually rather common with some elderly people who are experiencing Alzheimer's or dementia, where they may leave their home, perhaps not wearing the right clothes in the winter, subjecting themselves to real risk of exposure.
Absolutely. And so I think that picks up more on the adjudicated incompetent by a court, but so many people who are in that situation might have help from others to manage their affairs, but they've never been adjudicated incompetent. And the statutory requisites for doing so per state, I'm thinking of Florida here, sometimes are very, very difficult. And so again, just to carve out this area, if you have someone else manage your affairs, and even if, for example, Social Security knows of this and your checks are sent to someone who's sort of your assistant in that respect, that by itself does not mean that you are going to be reported to NICS as incompetent.
Okay, so that's an important distinction. So just because you're at an age or a mental state where you're not deemed to be competent to make, for example, financial decisions for yourself, that may not mean that it's enough that someone comes and takes away your shotgun.
Absolutely, yes. And I think when we see that picture of Americans with mental health needs, where we see a general trend and pattern that sort of goes against what we think with Americans with mental illness and firearms. So we tend to think that, the association between the two is quite high, when in reality, Americans with mental health conditions are much more likely to be victims of violence than perpetrators of violence. For example, estimates show that 95 to 97% of homicides by firearm are not carried out by individuals with a mental health condition. And so we have to look to other factors like a history of violence, being involved with the justice system as a youth, being subject to physical interpersonal abuse, and having parents who are involved with the justice system, as well as substance use and mental health conditions, being of a younger age, being male, coming from a lower income background. All of those are sort of risk predictors that would be used in terms of violence.
Jody, is this a bit of a solution without a problem? Is this missing the mark, attempting to reduce violence in a way that may or may not be particularly impactful?
Well, I think it's a start. And the courts and the law have never been very sophisticated at handling mental illness. And we need to look no further than, for example, torts and emotional distress and the very, strict elementary guidelines put in place there requiring, for example, physical signs to see that the law has an unsophisticated understanding of mental illness. And so it stigmatizes the many Americans who are living with mental health conditions that are actually not violent. And we miss the mark in a way because mental health conditions, while they're not related to violent firearm deaths, they are a predictor of violence towards self because they are a very good predictor of suicide. Most gun-related deaths in America are from suicide. And of course, if you're trying with a firearm rather than, for example, a pharmaceutical that's over the counter, you're more likely to be successful. Suicide attempts with a firearm are successful at least 85% of the time.
That's something that I did not know before doing some research for these conversations, which is a lot of attempted suicides are done with pills, and there might be time there for someone to be taken to one of our outstanding emergency rooms and brought back from the brink.
Yes, exactly. And unfortunately, this is one of the factors that have come under public scrutiny in recent years due to the extreme risk protection orders or red flag laws. And so I think we focus much more on individuals with suicidal ideation than we were able to before these laws appeared on the horizon of legal solutions.
Interesting. So this does seem to interact, or it seems to be very much connected to red flag laws in my mind, but it's different in the sense that under red flag laws, we're exclusively looking for those who are a danger to themselves or their community. Under some of the mental illness regulations, you're also taking away firearms from people who just don't seem to have what it takes mentally to handle such dangerous equipment.
Exactly. And that could be a transitory moment. I mean, there could be a moment, for example, where we suffer a depressive episode, we have a job loss, we have the loss of a relationship, a divorce situation. And I think state law is better at picking that up than the federal government standard, which requires, involuntary admission to a mental health facility or an adjudication of incompetence. Some states, for example, talk about those with an intellectual disability, which prevents the safe handling of a firearm. You lack the mental capacity to contract, which directly contradicts the federal law.
Fascinating.
And for example, access to hospitalization in an alcohol or drug treatment center. So if you are hospitalized, or going for outpatient services, you cannot have access to a firearm.
Got it. With any Second Amendment case, I feel like, I'm talking to you or another Second Amendment scholar, we have to talk about Bruen. Did the landmark Bruen decision change the way courts are analyzing these mental health issues?
Actually, very little. This is one of those long-standing prohibitions, to use language from Heller at the 2008 case, that sort of put us on the path
The
to
other
Bruen.
big one.
Yes, the big one. And so I think Heller had this category of long-standing prohibitions, and certainly denial of access to individuals with mental health conditions was part of that, as was the felon prohibitor and other matters, sensitive places. And so I think that Bruen basically said point blank, this was analogous to provisions that existed in 1791 or 1868. It's subject to longstanding regulations that we affirm from Heller. And so basically, this does not raise any problems. However, individual cases, I believe, could create Bruen issues depending on their facts.
In what sense?
For example, say someone had been involuntarily committed as a minor or a juvenile, and they're now 40 years old, have a stable job, have a stable marriage, have had no reoccurring mental health conditions, have never been hospitalized before, they're not on medication, and they basically want to uh, attain their firearm rights. Now, on one level, this might have been done because the juvenile record is sealed, but some states do have provisions where that information would still be accessible and be used to deny firearm access or ownership. And so, there are important, I believe, moments where you can restore access after a mental health adjudication.
That seems very important. And yeah, maybe we can talk a little bit more about restoration of rights. Is, for example, having a path to restoration, is that, do you believe, a constitutional requirement?
I do because, again, and it's required because not only because of the Second Amendment, but also for a more sophisticated understanding of what mental health conditions are. And again, we can have a diagnosable mental health condition, even one that we have for life, such as bipolar disorder or schizophrenia. But if we're medicated and we're taking our medication routinely, then in many states that is not a bar to accessing and possessing firearms or ammunition. And so I think that's a key both to not stigmatize individuals with mental health needs, to allow individuals with mental health needs to obtain the treatment they need without worrying it's going to permanently infringe upon their Second Amendment rights. And of course, to restore access to those whose mental health needs have basically terminated or are being managed such that it's perfectly safe for them to have a firearm.
And maybe they can change that language, calling our fellow citizens mental defectives.
Yes, absolutely.
Professor, maybe you could give us an example or two of how some states are treating this process of restoring access to firearms.
Yes, so that's a great question. So basically, states like Alaska allow someone to petition at any time, even right after they get out from an involuntary commitment. And some others basically say, well, you have to wait a certain period of time. Massachusetts mandates 3 years. Some states mandate 20 years. Some allow restoration of rights upon certification by a medical doctor or a psychiatrist. And Utah actually, and states like that, have a factors test that looks at, current mental health treatment, previous violent behavior, what medication you're on, are you able to sustain that medical or medication regimen, the length of time you've been stable, what external factors might influence stability, and in general, those sorts of questions that look at whether you're a danger to public safety.
Well, we know judges and lawmakers love a multi-factor test.
Yes, absolutely. And actually, some states don't clarify how someone who has this disability, this prohibitor, is ever relieved of this and could ever regain their Second Amendment rights. So it really spans the gamut.
Jody Madeira is a professor of law at University of Indiana, Bloomington. Jody, thank you so much for your time.
Thank you.